Good morning, everyone, and welcome to this wet Wednesday morning. Thank you for joining us at our breakfast online seminar. And today we are looking at how to get through ADR, dispute resolution, and keep your cash, which is going to be explained to us by Ryland Ash, managing partner of Silver Shinnings Ash. Good morning, Ryland.
Good morning, Julie.
Without any further ado, if you do have any questions for Ryland during the presentation, if you'd like to pop them into the Q&A tool in the bottom panel, and Ryland will endeavour to answer as many of those as possible at the end. So without any further ado, Ryland, over to you.
Thank you, Julie, and good morning, everybody. Thank you for joining us. So as Julie says, today's seminar is about getting through ADR and keeping your cash. Obviously, this is a particularly difficult time for many companies, and so keeping cash is a priority. The one thing I'd say about ADR, it's alternative dispute resolution. But people think of it as the back end of things. So when things go wrong, when it's irretrievable, when you've got no other choice but to look at bringing a claim, really that's not, in my view, not what ADR is all about. ADR is also about dispute avoidance. And I'm very much of the opinion that as much as you can do to minimize the risk of claims and disputes, you'll be in better shape to keep your cash. So there's a preventative aspect to today's seminar, and obviously a resolution aspect as well if things can't be resolved in an amicable commercial way. So you should be able to see my slides. I suspect that many of you have been to these seminars before, so I won't bore you with my background, but safe to say that I've dealt with a lot of dispute resolution over the 15 years that I've been involved in construction. So we'll start by looking at the different types of dispute resolution and compare and contrast those to give you a flavour of what options you have if you think things are headed towards a dispute. First of all, you have adjudication. Now, adjudication became a statutory right on the back of the Housing Grants Construction and Regeneration Act 96, which came into force in 98. So it's been with us now for a long time in the UK. It was used outside of construction prior to that in the context of smaller disputes, things like parking ticket disputes. You may have heard of the term adjudication, and it was more broadly used, generally speaking, to describe a process whereby a third party makes a decision. So the idea behind adjudication was that you would have a 28-day process, and at the end of that 28-day process, the third party adjudicator would give their decision, and they would say which party they'd agreed with, how much a claim was worth, if that was the question before them, and then they would make a decision on when and how payment would be made. So adjudication is a kind of interim dispute resolution process because it can be overturned by a court or by an arbitrator if there's an arbitration provision in your contract, but it's temporarily binding on the parties. It's as if the adjudication itself was part of the contract when the decision is made. Arbitration is the final port of call for a dispute where you have an arbitration provision in your contract, but you have to have a valid arbitration clause for arbitration to apply. Otherwise, the last forum for resolution will be court proceedings. So it's an either or. You either go to court or you arbitrate. There are certain circumstances in which you aim to go to arbitration, you actually end up in court because there may be parts of an arbitrator's decision, or the decision itself, or the jurisdiction of the arbitrator which is in question, in which case you can end up sometimes going to court to get a decision about the arbitration. But that tends to be quite a sort of narrow category. So arbitration is, by comparison to adjudication, final. It's similar in the sense that it is generally private, and that's the main reason why parties would prefer to arbitrate a dispute rather than go to court. If you're in litigation through the courts, then it becomes public knowledge, and the documents submitted in the cases are within the public domain. So if you want to avoid publicity, then arbitration is a good choice. In terms of the last two, mediation and conciliation, they are more where you're seeking to try and resolve the dispute by way of agreement, particularly in mediation. So mediation will be behind closed doors. You'll have a third party mediator. The mediator can meet the parties individually. And then what they try to do is to get the parties to come to an agreement. Whereas with adjudication and arbitration, you're waiting for a decision. And the mediation is generally without prejudice, so that anything said as part of the mediation can't be used against you later if you don't resolve the dispute during that time. Conciliation is something that's not as widely used in the UK or even in Europe as much. But in Southeast Asia, for example, and in other countries, conciliation is used. Conciliation is more of a combination, really, of mediation and adjudication. So you'll start off generally in the same way you would with the other proceedings, setting the parties' positions out. You'd meet with a conciliator or a panel of conciliators. I was involved in a number of conciliations in Taiwan in relation to the Taiwan High-Speed Railway project, where we had a panel of conciliators or a single conciliator. And what they will do is they will seek to mediate, first of all, seek to bring the parties closer together in the terms of their positions, understand the parties' positions, point out weaknesses and strengths, manage expectations effectively. And if that can't resolve the dispute, then the conciliator will then make recommendations or even a decision on what they think is the right answer. So in that sense, you get an answer, but it's usually, depending on the way that the conciliation agreement's drafted, is usually not binding. So it's a recommendation to say, if this were to go to court or to an arbitrator, in their view, what would happen? And so you get a good idea of how things are to be, would be resolved if they went further without resolving the dispute. So they're the main types of dispute resolution. Obviously, you've then got litigation itself and going to court, which is a different process altogether. But today's seminar obviously is focusing on these things, on dispute resolution as opposed to court proceedings. So how do you get through these processes, and keep your money, or at least succeed? So there are a number of things that you need to consider before you embark upon one of these often expensive processes. And the key to success in any of these types of proceedings is preparation. And by preparation, I mean starting from the fundamental basics by taking good legal advice, understanding your position, understanding the law, and then from that point, building a case based upon those principles and building it in such a way that it's persuasive, that there is evidence that supports allegations that are made and claims that are made, and if necessary, bringing in other types of evidence such as witness evidence or expert evidence on certain points. And ultimately what you're trying to do is to overcome or satisfy the burden of proof. That is, that you can prove your case on the balance of probabilities. Is it more likely than not that you're right about your position? Now, of course, if you're defending a claim, you're going to go through the same process, really, because you have to analyze what's being put forward. But when you're defending, often there's more strategy involved in terms of how you're going to defend your position. And in some ways, ADR as a defendant can be very useful because you can break disputes down into aspects where you may feel you're stronger or that the claim is weaker, and begin to sort of slowly dismantle a claim and then ultimately settle it and get rid of it. So defending is sometimes more tactical in that sense. So we start with arbitration. As I mentioned, it's private, not in public, which is attractive for many reasons to parties. You get an impartial professional arbitrator, or at least you should choose one that is such. Sometimes they may be retired judges, QCs, barristers, and so they know the processes very well, and they'll be able to give you a view on what would likely happen if you were in court, for example. But the arbitration is going to be the final resolution forum. So in the arbitration, you have to pay for the arbitrator's time. You have to pay for the venue, but you get the flexibility over who the arbitrator is and where you want the arbitration and when. So it's unlike court proceedings when you're told when things happen. So there is that added flexibility and the privacy factor in its favor. There are limited grounds to appeal an arbitrator's decision, and the arbitrator has the power to order costs. Those of you that are familiar with litigation will know that you can appeal litigation, but appeals can often take a long time unless they're expedited, as do court proceedings. Not to say that arbitration doesn't take a long time as well if it's a big case, but court proceedings are notoriously slow. And in terms of costs, interestingly, in litigation now, costs have to be proportionate, which broadly means that costs shouldn't really outweigh the amount being claimed and should be proportionate to the amount in dispute. And so for that reason, often costs aren't always recoverable, even though you've perhaps spent good money on a good claim. You won't always get that money back. Generally speaking, in courts, if you succeed, you get 60 to 70% of your costs back, which is the standard order. Whereas in arbitration, you can certainly make arguments to say that you should recover more than that. And the arbitrators have very broad powers generally to make those cost orders. And there's no fundamental requirement for those costs to necessarily be proportionate. So they would have to be realistic and reasonable, but not necessarily proportionate. So it may be that you can recover more costs in arbitration. But the parties have to agree that an arbitration clause will be in their contract. And so often you'll find them in more sophisticated contracts and international contracts. I've worked on a number of international projects where you have international arbitration clauses, perhaps because the works go across different jurisdictions, or you want to ensure that the contract and any disputes are subject to a particular area of law or country's law. So you can effectively agree the law that applies and the place where the arbitration is going to take place. And it could be anywhere. So you could have a job in Qatar, but you have arbitration in Amsterdam or London or wherever else. And so you have that flexibility to suit the parties, really. In terms of mediation, mediation is a bit of an art. My own view about mediation is that it will only work where there is scope for settlement. And I say that because if the parties are so far apart, and for example, both parties think they're entitled to be paid, then often it's virtually impossible to get to a settlement without a decision of a third party saying which party's right, because there's such a hurdle to overcome in that situation, psychologically, for each party to go from a position where they're saying, well, I'm expecting X amount of money and I'm going to forget about that. And not only that, but I'm going to pay somebody else money. It's very difficult to persuade someone in that way. That's not to say that it doesn't happen. And I've been involved in cases where it has, where I've managed to persuade another party and a mediator to an extent that although a claim was being made against my client, actually my client was owed money. It happened to be in respect of other projects. And so it can be a very successful process. But as I say, I think it works best where the parties essentially are closer together. And it's not really, excuse me, it's not really a question of who gets paid, but more a question of if someone gets paid, and if so, how much. And really the how much cases tend to be probably the best, or have the best chance of success in mediation, because you haven't got that psychological barrier to break through. It's entirely voluntary, of course. You don't have to do it, but before you go to court, if you're thinking about going to court, the court process does encourage you to go to mediation beforehand. And if you don't do that, there can be cost consequences for failing to do so. So if you don't have arbitration clauses in your contract and you may end up in court at some point in the future, then mediation is definitely worth exploring from the outset. The difference between mediation and other processes is that the whole thing is supposed to be without prejudice, which means you can pretty much say what you like, submit what you like. And in that sense, it can be quite cathartic for parties to get things off their chest and provide their evidence in support of their position. The other difference is that a mediator will be able to speak to parties independently and separately, and together and all together. Some mediators don't get everybody together at all. They just work on parties individually and try and get them to do a deal. But most of the sort of higher value mediations I've been involved in, they do tend to be more formal, in the sense that you'll have an opening session with a mediator where each party puts their positions, and then the parties break away into their own rooms. They spend some time with the mediator working through their position, and the mediator will shuffle in between those two rooms throughout the day, or weeks or months, however long it takes. Tends not to be months, but sometimes is days. And we'll try to get the parties to come to some form of agreement, generally by picking off issues by issue and encouraging the parties to moderate their expectations in relation to each of those points. So that's mediation. And if it's successful, then you'll end up with a settlement agreement at the end of it. And that will be binding on the parties if they so agree. So it's a very useful process often as well to get a feel for the strength or weakness of a position before you go into formal dispute resolution as well. And so for that reason, I would always recommend it, notwithstanding how far apart the parties are. In terms of the costs, normally the mediator's costs are split between the parties, and the parties bear their own legal costs for the process. But that can be varied in the settlement agreement if one is reached at the end of the process, depending on the outcome. So I mentioned conciliation. Again, it is an alternative dispute resolution. Like mediation, it's voluntary, it's flexible, it's confidential. The parties seek to reach an amicable settlement with the assistance of a conciliator who acts as a neutral third party. The conciliator, like a mediator, will develop the arguments and then sometimes they'll propose terms of settlement to the parties rather than it being led by the parties themselves. And as I say, they make recommendations effectively on what they think a settlement would look like. So it's a more engaged process, more proactive from the perspective of the conciliator, as opposed to a mediator who stands back and lets the parties make the moves effectively. Adjudication is now probably the most common of all ADR processes in construction law because of the advent of the Construction Act and because of its success ultimately. I think that, you see, in my experience, maybe 90% of cases that go through an adjudication tend to stop there. And so it's achieving its aim, which is to resolve disputes relatively quickly, relatively inexpensively, and the parties are getting decisions that they're reasonably happy with. Obviously, you can't keep everybody happy in a dispute, but the question will be, is it clear? Is it reasoned as a decision? And can you see that the likelihood is that if it then went on to court or on arbitration, would the same decision be made? Would the same outcome be achieved? And if that, the answers to those questions is yes, then it's likely the parties will look at it and accept it and move on. Now, the downside to adjudication is that it is very much considered a pay now and argue later mechanism, in the sense that it's interim. But as I say, that doesn't necessarily mean that it's not effective in resolving disputes. It just means that it may not be the end of things. And so really that's the balance to strike. It tends to take 28 days is the set procedural period for an adjudication, but invariably they are extended. They can be extended by an agreement between the parties, or if it's under the scheme, then the referring party can extend the adjudication by 14 days. But there are very strict limits in terms of complying with the adjudication. So, for example, if you refer a dispute under the wrong nominating body, or if you issue a notice and then refer a dispute too late, these things can be fatal to the process and effectively mean that the whole thing falls apart. It will become unenforceable and a waste of time and money. So it's extremely important that when you're going through an adjudication or considering adjudication, that you take good legal advice, and that you have somebody holding your hand through it or running the case for you to make sure that you avoid these common pitfalls. Once you get the decision of an adjudicator, as I mentioned earlier, it becomes temporarily binding. And if a party who loses an adjudication refuses to make payment, then you can seek to enforce that decision in the courts. And that's by way of what's known as summary judgment. A summary judgment application is made in the High Court normally, and then there'll be a hearing for summary judgment. And the process of enforcement is a very effective one. I would say, again, probably in the 90% cases are enforced by the courts. And so it's quite rare that a decision will be overturned by the courts. And for that reason, adjudication is very effective. In terms of the adjudication itself, the decision of an adjudicator is binding until the dispute is finally determined by litigation or by arbitration or by agreement. And so for that reason, it's often accepted. It's only where the parties disagree fundamentally with what's been decided that they may think that it's worthwhile having another go running the same arguments before a court and an arbitrator. Only disputes under the contract may be referred. So it's limited to arguments that relate to disputes under the contract. In other words, you can't really have an adjudication in relation to whether a contract exists, albeit that often that can be an issue within an adjudication. It can be a dispute, maybe about the value of the works, and then there may be a challenge to the adjudication on the basis that actually there is no contract. An adjudicator will then often express a view on that, make a decision as to whether they want to continue with the adjudication. And if they do that, then obviously the adjudication will continue and you'll get a decision. But the question over whether there's a contract is more about the power to make the decision, the jurisdiction of the adjudicator. And if that's still in question at the end of the process, then that might be something that a court would look at. You can't adjudicate over claims just in tort or for misrepresentation or for rectification under the contract due to mistake, as these are not necessarily claims under the contract itself. So there are limitations to what you can adjudicate upon. The parties must have a dispute or difference. So you have to have a dispute crystallized under the contract, which means it has to be very clear what each party's positions are and that they're actually in dispute. What you can't have is one party unilaterally saying this is my position and the other party not giving an opportunity to respond and then seek an adjudicated decision, because the dispute in that case wouldn't have crystallized. So effectively, you need a reasonable opportunity to respond to a claim or a position, and then a dispute will crystallize. In terms of the procedure, you can agree an adjudication procedure in a contract, but there is a standard process which is in the scheme for construction contracts, and that's a statutory instrument referred to in the Construction Act. And so normally parties would just adopt the process in the scheme. And if you look at the JCT contracts, for example, they do that exact thing. They refer to the scheme process. And the rules are effectively that you start with a notice of adjudication, you have a referral. The adjudicator has the power to determine the facts and the law, and then they make a decision within 28 days. So this is the process here set out in the slides. You start with the notice, the referral is day 0. You will normally, as a minimum, have a response to the referral. You quite often will have a meeting if it's necessary, by video conference at the moment, most of the time. Then you tend to get a reply, or the adjudicator may say at the meeting that they want further submissions on certain aspects. Then you may get a rejoinder in response to that reply. You may get further submissions after that. Documents in support often include witness statements now, because statements in pleadings, in the submissions themselves, is often not enough. You need somebody who's prepared to give a witness statement and swear that it's true, to actually support what's being said. And you may also, increasingly now I'm seeing expert evidence in adjudication in relation to obviously technical aspects of the dispute. I mentioned that if you win in adjudication and the losing party refuses to pay, you can seek summary judgment. Going right back to the beginning, one of the first cases, Macab Civil Engineering, they set the tone in the TCC by saying, unless there's a very clear breach, we are going to enforce adjudicators' decisions. You must pay now and you must argue later in court if you're really serious about challenging this decision. And so enforcement's a very powerful tool. It's a quick tool. And unlike adjudication, if you enforce a decision, you can seek the costs of doing so from the losing party. So that's a big stick to wield. If you've been successful in adjudication, you can do that very quickly. The other thing is that it's been decided, and this may seem counterintuitive, that the courts will enforce an adjudicator's decision even where they've answered the question incorrectly. The only thing really that will allow a party to challenge an adjudicator's decision is where they've answered the wrong question or where there's been a breach of natural justice. And they're known as jurisdictional points, where the adjudicator simply didn't have the right to make the decision that they made. And so you can see there's a case involving Bouygues and Dahl Jensen 2000. The courts are quite clear that if you answer the wrong question, then your decision will not be enforceable. So what arguments can you run to avoid enforcement of an adjudicator's decision? Well, you cannot say that you just disagree with what the adjudicator said, and you can't say that you want a different decision because you think he got it wrong. That's not going to wash. The most common successful arguments, and as I say, there aren't that many, are that there was no contract, that the adjudicator didn't have jurisdiction to make the decision that they did. In other words, the process was wrong in some way, or they didn't have a right to make the decision they did. The adjudicator acted contrary to the rules of natural justice. Let's say that they completely ignored one party's submission, for example, or they spoke to parties individually without engaging with the other parties. That could be another ground for challenge. The dispute is the same as one that's already been referred. That would be grounds for challenge. Or the adjudicator, as I said, answered the wrong question. So any of these things might give you a right to challenge the decision and get it set aside. Other things in terms of the defects in the decision could be the adjudicator wasn't fit to make the decision. There was bias, if you can prove it, dealing with an issue that's not part of the adjudication, failing to deal with a matter that was, an unclear decision, an illegal decision, in terms of sort of bribes or anything untoward or criminal, and then just a general breach of natural justice by perhaps not following the process properly or having some form of conflict of interest potentially. So these are the types of things that can get you out of a decision from an adjudicator. And if that's the case, then you're likely to, you could go back to adjudication if the decision has been rendered unenforceable, or you have the option to go to court or arbitration, depending on whether your contract includes an arbitration clause. Turning now to financial claims, the thing to distinguish if you're going to be successful is first of all a claim under the express terms of the contract and claims at common law. And you can remember that if the contract doesn't state that your common law rights are excluded, then they will apply, in which case you can make claims in the alternative at common law. So you could make a claim under the contract or at common law, and you could make the same claim effectively, but referring to the alternative grounds. In terms of administration and communication of claims, there are various things to consider, and this is more of a sort of checklist for you and things to consider when you're preparing or defending claims. First of all, in terms of the common law and contract, obviously, if there are rules in the contract itself, they must be followed. If the contract says that things should be in writing, then they need to be. And if they're not in writing, then they're effectively irrelevant, can't be relied upon. Emails generally are considered now to be in writing or an acceptable form of communication. But in adjudication, you need to check the rules, because the adjudication rules may say that things have to be issued by way of post. And if that's the case, then emails may not be sufficient, and you may end up with an unenforceable decision on that basis. In terms of whether things are issued, they can be posted, of course. And if you've got proof of postage, then that always helps matters. You have to check the express terms of your contract to determine what those rules are, of course. If your contract says that a signature is required for something to be valid, then of course that would be a prerequisite. So again, this is just a general point about complying with the contract provisions. In terms of emails, obviously be careful with emails, because they tend to get issued more frivolously and more quickly. And so if that happens, then faults are common. And obviously sometimes they can be issued to the wrong people, and they can be lost. They can even be amended. So not as reliable as post, really. But nonetheless, if you've got evidence of emails, then generally that should be enough, unless your contract says otherwise. PDFs can be very useful, but they can be amended as well now. And it's more prevalent to have software to be able to do that. But generally, issuing PDFs compared to a Word document, of course, is much safer. Faxes, although they're old-fashioned, can be useful, because you often get a receipt from a fax, which tells you the time and when things were issued, which is very useful. In terms of verbal communications, obviously you need to be able to prove things that are verbal. And so if you've got them in writing, then that will persuade a judge or an adjudicator one way or another normally. If you end up in a situation where you're making verbal agreements in respect of a project, then obviously make sure, if you can, that you put things in writing, and at the time is a more valuable approach. If you've had to rely upon things that happened at the time a long time ago, and you don't have any proof of those things, then often it's difficult to demonstrate to a third party that they actually happened. In terms of the postal rule, the JCT says that if you post something, it's deemed to be served 2 days from issue, but you obviously need to prove when you issued it. So if there are strict timeframes in your contract, then obviously they have to be followed, and you have to apply that 2-day rule. In terms of telephone calls, you can record telephone conversations, but you have to be prepared to tell someone that you're doing so. Otherwise, it could be considered entrapment. And you can have telephone conversations then transcribed by a commissioner of oaths and then signed as a sort of witness statement of what happened. And that way they can be more valuable. Without prejudice communications are communications that can't be shown to a judge unless or until the case is over. And this can be very useful in terms of trying to negotiate particular points. And so these should be used to assist in negotiations. And they won't be visible in disclosure either if you get to that point in litigation. Without prejudice communications, save as to cost, basically means that you can't look at these communications unless it's in relation to costs. And when costs come up after a case is over, you may then look at them. In terms of privilege, if you're communicating with your legal advisors, your lawyers, then this will remain private. But obviously you need to make sure that it's clearly stated that you are communicating with them for the purpose of legal advice. In terms of the certifier, the role of a certifier, they should be acting independently. So a contract administrator, for example, under a contract or an architect has a duty to act independently. And the certificate itself may be a condition precedent to something else. So without a certificate, you won't have a right to payment. Without a certificate, it may be that completion hasn't happened. And there may be a question of fact over that, but ultimately, if the certificate hasn't been issued, then under the contract, nothing has happened. A failure to issue cannot prevent or preclude an entitlement. So you can't refuse to issue a certificate and then prevent something from happening. And a court or an arbitrator may decide that in fact a certificate should have been issued, and effectively they can then decide that it was issued. In other words, no party can take advantage of their own breach of contract. When should you not communicate? Well, it's important that if you're asserting something, then you must prove it. And equally, if you're receiving an allegation of something, that other party must prove it. And there's also a rule against self-incrimination. In other words, you can be silent about something, but ultimately you don't have to comment on it if there is a question over whether or not it's something that you need to explain later. The burden of proof is something that happens in all cases. You have to prove things on the balance of probabilities in a civil case, and in a criminal case, it has to be beyond reasonable doubt. If you'll excuse me just for one moment, I will be back in 2 minutes. Thank you very much. Just bear with me 2 minutes. I will be back and I will continue the seminar. Thank you. Going back into administration and communication. Now, ultimately, as I've said, he who asserts must prove. The balance of probabilities is the standard of proof. However, sometimes it's a good idea not to comment on particular issues, creating evidence that will work against you, for example. So if there are allegations which you simply can't explain, sometimes it's better to not say anything. But the rule against self-incrimination will help you in a criminal sense. But in a civil sense, if you do have a weakness in your position, often it's better to just keep quiet about that issue. In terms of evidence and records, even if you've got the best case in the world, if you don't have evidence and records to support it, ultimately your claim is not going to succeed. So there are a number of things that I would expect to see in a successful claim, and they will include notes from the time when things happened, so contemporaneous notes. Also, the records themselves need to be clear. They need to have dates, in particular with photographs. Photographs are very useful, but they need to be in context. You can't just have close-up pictures of various aspects of the work without explanation. The amount of times I've seen people say, I've got brilliant records, and you go through the records and you realize that actually it's very difficult to tie those records into what is effectively the evidence of the allegation, and so they're worthless. So it's very important that things are put into context. In terms of the form of the records, doesn't really matter as long as it's clear what they are demonstrating. They can be used as evidence later. And minutes of meetings are obviously crucial because they are created at the time to reflect conversations and events that happen. But it's important that they are accurate, and if they're not accurate, or you have an issue with a certain set of meeting minutes or points within them, you must question them at the time. Please don't let things lie that are inaccurate. Too often, I'll see parties will be adamant about the fact that things in minutes are not correct, but ultimately they're not challenging them. You really need to do that at the time when things are recorded, and record your own version. As I said, photographs are great, videos even better, as long as they've got the correct descriptions. Contemporaneous records are records that are created at the time. They're more valuable than records created later because they're seen as more credible about what actually happened at the time when things occur. Letters and correspondence obviously can be relied upon, and you should be writing letters which support your position throughout the contractual period. Obviously, you should be giving notices if the contract requires them, following up on those notices, following the contract process. That will all be very helpful. In terms of the type of document, obviously there's a whole range now of different types of electronic document that can be relied upon, and there's no real limit to that. You can rely upon everything from Instagram pages, WhatsApp messages, pictures, and so on. But obviously you have to have them archived properly and available, and be careful that they're obviously kept safe, because they can be lost fairly easily if you get a new phone or a new computer. So keeping those records archived properly is going to be important. In terms of records and evidence generally, they can be a friend and a foe. And what I mean by that is, if you end up in court proceedings, for example, you'll have a duty of disclosure, which means that all documents, whether they support your case or they undermine your case, have to be provided to the court. And this often reveals documents which don't help you, which work against you. And they could include directors' meeting minutes, internal cost records, profitability forecasts, internal memos, computer records, even consultants' advice to you. Not legal advice, because that would be privileged, but certainly consultants' advice or reports. So you need to bear in mind when you're creating documents and keeping records that things could be used against you later. So whilst you're creating these documents, think about that purpose. And effectively what I'm saying is, try to only create documents that support your position. Don't create too many documents that undermine your position, because even though they may be private now, if things go to litigation, then they won't be private anymore. They'll have to be disclosed. And at that point, you may undermine your position. So there's a famous saying in arbitration, there's three things to remember: the importance of records, the importance of records, and the importance of records. And that can't be understated. In terms of notices, I think it's important to start by saying that if a contract says you must give notice, if you don't give notice, you lose your right to bring a claim, what's known as a condition precedent clause, then the courts will uphold that provision. You will not be able to make a claim where you haven't followed a process in a contract that is a condition precedent to entitlement. So your notices have to be in the correct form, they have to be issued at the right time, and notices under the procedures in the contract also have to be issued. For example, contracts where a notice to commence needs to be given to kickstart a contractual period, they have to be issued. Notices of delay, notices of payment, payment notices, pay less notices, and so on. All of these things are critical often to succeeding or defending a claim. In terms of the form of records, obviously you've got the contract documents that you start with, and it's important to try and have clarity about what is incorporated into the contract from the outset. That may sound obvious, but believe me, it's not always clear cut. The number of cases that I see, it just never ceases to amaze me how many times you'll get a set of contract documents which refer to other documents, or you get a simple contract that refers to other documents and you can't find them, or there isn't a version, a particular version that's been identified. There may be several versions, and there's uncertainty even from the outset about what the contract documents are. But a nice tidy bundle of contract documents is obviously an ideal starting point. In terms of minutes of meetings, I've already said, contest them promptly or accept them, but make sure that they're accurate. Date stamp your photographs and your contemporaneous documents. Please make sure the dates are accurate and the info is accurate. I've mentioned letters and correspondence. They need to deal with the position in your favor. Be careful not to be too generous in writing. Obviously, when you meet with parties, you can discuss things openly or on a without prejudice basis if you're looking to make concessions, but don't make concessions in writing is my advice. And be careful what you say in writing, particularly within emails as well, because it can seem informal, but as soon as you get into a dispute, it will become formal, believe me. Your own diary entries can come out in disclosure later. So again, whilst you think a diary is a safe place, not a personal diary, of course, but a work diary or a diary of works, ultimately, that could become evidence that could be used against you. So be careful what you record in diaries. Programs, progress reports. In theory, you're producing programs. What you really want is programs that you produce for the benefit of the other side, and then you might have separate programs which show for an internal analysis, which you obviously need to keep private. So be careful what documents you create, I think, is the overall flavor of this section of the slides. In terms of timing is really everything, and particular in relation to contract formation. At the beginning of your contract negotiations, there'll be toing and froing, and what's known as the battle of the forms is where there's a disagreement over what's the basis of the contract. The bottom line is the last person, the last shot to go in before contract is formed is often the crucial one. And so, the timing of communications is very important. Always have the last word, I tend to say. That would put you in good stead to win the battle of the forms argument. If things are signed for record purposes only, then that's exactly what they are. They're not being admitted or agreed. If they're signed by the issuer but unsigned by the recipient, then that's better than nothing. If they're signed by the issuer and then challenged or amended by the recipient, then ultimately that's often seen as a counter offer, which would displace the original offer. But if it's not displaced or it's not disagreed with, then sometimes it can be seen as accepted. It depends on how the response is communicated. And if it's signed by the issuer, unsigned by the recipient, and challenged much later, then it's quite a difficult challenge to make because you've acted in a certain way which is consistent with it being issued. So your conduct will come into play at that point, which is not really an argument that you want to be running because it's unlikely to succeed. Obviously, you have communications at different levels, and it's a good idea to obviously keep things at equivalent levels because there tends to be more scope for agreement. As soon as someone senior comes in, sometimes there can be disagreements between personalities which create disputes rather than actually issues of principle. Be consistent in your style and structure, be concise and factual, base your statements upon what's happened and what you can prove. More importantly, avoid emotion in written exchanges in particular. Make your point. So introduce what you're going to say, state it and describe the facts and refer to the evidence if you can, but take advice on these things in the background is my general advice on the content and drafting of letters. Try to bring an exchange to a conclusion. Try to agree points and then establish what's not agreed and work through those points and work out where your differences are, and then take advice on those points to see how strong your position is. You don't have to overquote contract clauses. It's sometimes tempting to do so to demonstrate that you know what you're talking about. Obviously, if you're bringing a claim under a particular provision, then it's important to identify them, but don't overquote. In terms of the language, no reason to make it overly technical or legal unless you've got some good references from your advice that you're taking behind the scenes. The most important thing when it comes to evidence and drafting is to link the causes with the effect. That's really part of the legal analysis that will need to happen at some point if the dispute goes further. So linking cause and effect is going to be key. The cause or the clause with the effect and the costs or the impact or whatever it might be that you are claiming for. In terms of documents you're going to produce, I would recommend having a diary on site, recording the work done, the duration, notes of conversations and details. Always reply appropriately in detail as soon as possible to allegations of default or claims. Protect your position. Don't ignore allegations. You must deal with them at the time, deny them in the first instance if there's not enough evidence, because that evidence itself may be used against you later if you don't. Ensure that meeting minutes are accurate. I'm becoming a broken record here myself. Constantly monitor progress on site, communicate hopes and misgivings, communicate mitigation, confirm drawing issues, maintain a drawing register, monitor and record labor on site just as much as materials. Often it's very clear to follow the process of construction in terms of what's been built, but the labor records are often missing. Labor records become critically important in relation to loss and expense, which is one of the most difficult things to prove. But if you've got the labor records and you can show how resources increase and decrease over a period of time, then that will be really useful when you're coming to bring a claim. Confirm verbal instructions in writing. Contractually important, tactically important, and confirmation should be written, submitted as soon as the instruction is given, ideally before compliance, and obviously submitted to the appropriate person. I've given you some more notes here which you can take away in terms of what detail should be within your records in terms of plant and materials. Please take note of these. Make sure you've got this level of information in your records. These are the types of things that are sort of on my wish list when I'm looking to bring or defend claims. I'll be looking for this information and asking for it. So overall, from a legal perspective, if you're bringing claims or even defending them, what should you expect to see to be proven? And how will records help? The key thing in English law is to overcome what's known as the two-stage test in the good old case of Hadley and Baxendale, 1854. And this case is still good law today. And this case involved a crank within a mill that was turning. It was a water mill turning, grinding down meal to be sold on the open market. The crank itself cracked and broke, and a replacement was ordered from Baxendale. Baxendale said that they could deliver this crank within a set period, say 2 weeks, and obviously up through, at that time, through horse and cart on canals, and however they were going to get this heavy piece of machinery delivered to Hadley. And it was delivered late. And Hadley said, well, because it was delivered late, we can see what our income was for the period up to that point, and we've lost revenue as a result of you delivering this piece of machinery late. And the court said, well, unless you make it clear from the outset what your losses will be, you can't expect a party to be responsible for all of those losses. And so the court set out a very clear two-stage process for assessing losses for breach of contract. The first test was, is it a natural consequence of the breach of contract? Does it flow as a natural consequence of the breach of contract? And if it does, you can tick it and it will be recoverable as part of damages. And the second test was it within the contemplation of both parties when the contract was entered into? And that's why you have provisions in contracts for liquidated damages, for example, which will say, you know that if you're late on this project, I will incur X amount of losses, and you agree that you'll be liable for those losses if you can't complete within that time frame. And because it's within the contemplation of both parties, it falls under the second limb of Hadley and Baxendale, and therefore it's recoverable. So is it a natural consequence? Is it within the contemplation of both parties? And if the answer is yes to either, then it's something in principle that you can seek to recover as a result of that breach of contract. So in conclusion then, in terms of what you can recover in a claim and how to best keep your money through ADR, the key answer to that question really is preparation. It's keeping good records throughout the process, from contract formation through the contract process. Keep records that support your position, make sure they're accurate, build up this brief of evidence, which you hopefully won't need, but if you do, you know that you can rely upon later and that it's accurate. And really, that's the key to keeping your money in and through ADR. And once you get to ADR, obviously choose the correct process that's suitable for you. Adjudication is a very successful procedure for resolving most of the disputes in construction today, but the evidence will be critical as to whether or not you succeed. Thank you very much for listening. I hope you found that useful. I'm going to pass over to Julie now, who's going to relay any questions that you may have.
Okay, Ryland, we don't actually have any questions submitted yet, so if anyone does have a question, please let us know now, the Q&A or the chat box. Otherwise, I'm sure that if there's something you don't wish to ask at an open forum, if you email Ryland Ash at silverllp.com, as is up on the screen, Ryland will be only too happy to answer specifics for you. Other than that, we will say good morning to you. Hope the weather isn't too bad where you are. Have a good day, and thank you very much for joining us. Hope to see some of you again at 6 o'clock tonight for our evening seminar. And thanks to Ryland for your time.
Thank you, Julie. Thanks, everybody.
Take care all. Bye-bye.
Bye-bye now.